Chers collègues, bienvenue.
Colleagues, welcome. Senator Fraser is absent today, and so I have agreed to replace her in the chair. Today, we continue our consideration of Bill C-15, an act to amend the Controlled Drugs and Substances Act, and to make related and consequential amendments to other acts.
This Canada, we have Maître Paul Saint-Denis, Senior Counsel, Criminal Law Policy Section. Mr. Saint-Denis is here today to answer technical questions member of the committee may have regarding the bill. As such, he will not be making an opening statement. Welcome, Mr. Saint-Denis. You and I have been discussing that specific subject, or I should say that large subject, for many years, and I welcome you to our committee. I'm sure colleagues will have very interesting questions for you, and we'll start right away with Senator Baker.
Thank you, Mr. Chairman, and welcome, Mr. Saint-Denis. I don't know if you're going to be able to answer the two questions that I have for you, but I'll put them anyway. It's the two things that sort of stood out to me when I read the bill. The first question relates to Section 8 of the bill, under the heading of notice. And it appears to me that the scheme of the legislation appears to be, if not exactly the same, then mirrored on Section 255 of the Code with the enabling Section 727. That's the impaired driving. When you get to your second or third offense, there's a minimum sentence. And the triggering point is that the Crown Prosecutor, as Section 8 here says, must satisfy the court that the person has been notified. The words here are, was notified, quote, this is Section 8 I'm reading from the bill, of the possible imposition of a minimum punishment for the offense in question, and of the Auditor General's intention to prove any factors in relation to the offense. Am I correct in interpreting that as being a similar scheme whereby the Crown Attorney is a person who tables, or not tables, but who enters the person's previous conviction on the record of the court, and that person has been so warned prior to plea?
That's partially correct, Senator. In point of fact, as you go through the bill, you'll see that there are a number of aggravating factors which could lead to a minimum penalty. So the notice provision here is really for forewarning the accused and the court that there's a possibility that a minimum penalty will be sought. And in order for the minimum penalty to be applied, then certain factors will have to have been proven in court. But it's to give fair warning. Without that, there would be no minimum penalty imposed.
Now, the reason why, and your last sentence there, and if that is not done, no minimum penalty will be imposed. Now, that is the scheme of 727 of the Code, without making reference to it, as it relates to impaired driving. That is exactly what you just said. And if the Crown Attorney does not enter the previous conviction, then a minimum sentence cannot be imposed.
Well, actually, what the provision says is that the court is not required. So it doesn't mean that the court can't. But the way the scheme is set out is that the court must, if certain things have been proven and there's been a notice given. Absent a notice, the court may choose to impose a minimum penalty, but it does not have to. And you keep referring to the prior conviction, Senator, but it's not just prior convictions that would trigger a minimum penalty. It could be a range of different things. For instance, the use of a weapon, use of violence, gang-related so on and so forth.
Yes, but it also includes previous convictions.
It would include a prior conviction.
Yes, of course, because that's the triggering point of a section of this bill. Now, here's my concern, and I don't know if the Department has thought about it. In the past year or so, there have been a multitude of cases that have decreed that this violates the Charter, Section 7 of the Charter, fundamental rights, that the discretion to enter the record is in the hands of the prosecutor. Now, I have here several cases in front of me. It's from the Ontario courts that is very clear about it, and it dates back to a decision of the British Columbia Court of Appeal. In other words, what these court judgments have said is that the discretion in the hands of the Crown prosecutor should not, that only Parliament and the court have the right to impose a sentence, that the discretion held in the hands of the Crown in this instance is unconstitutional and violates fundamental justice. Have you considered that? You may not want to answer that question.
No, I don't mind responding. I'm not sure I'll be able to answer, but I know that the issue of Crown discretion is something that is sensitive to the courts and to others. To my knowledge, the courts have generally acknowledged that Crown discretion is, by and large, constitutional. These cases that you're referring to I'm not familiar with, so I can't comment on them. But really, and your point being here is that only the courts and the legislator can determine sentencing or can set out the parameters for sentencing. That doesn't change with Crown discretion. And the Crown has always had the discretion to present certain factors going to aggravating, certain aggravating elements to a crime, the result of which would be an increase in the penalty. And that's never been contested, to my knowledge. So, I mean, the Crown here is not really imposing a sentence. The Crown can choose to bring forward certain elements, the result of which would be, if it's proven, a minimum penalty, or not.
Yes. I'll just read the title of both cases, if I could, Mr. Chair. R.V. Gill, this was less than a year ago, Ontario Court of Justice, 2008, Carswell, Ontario, 6139. And the other one I picked up was just prior to that, the Ontario, it is R.V. King, 2007, Carswell, Ontario, 3314. Both of these cases, the most recent one, cites a multitude of cases upon which, yes, prosecutorial discretion cannot be questioned. But when prosecutorial discretion is used outside of the core duty of a Crown prosecutor, which is to bring something to trial, to handle it as it goes through and brings it to a successful end, or an unsuccessful end, whatever the case might be. But this is outside the core responsibility, and the courts have judged this to be unconstitutional as it relates to the Crown having the discretion as to whether or not to impose a minimum sentence. I understand what you're saying, that you say, well, they're not really in the Crown's hands, but if the Crown doesn't enter the evidence, then the minimum sentence doesn't apply. My second question, because the Chair is not going to allow me very much time.
I will say, probably Mr. Saint-Denis, if you want, obviously you're not aware of that jurisprudence.
No.
And maybe you would want to read it before commenting on it. Maybe you would do that in writing.
Mr. Chairman, I am not familiar with these cases, nor am I familiar with the level of case. If it's a trial division decision or if it's a Court of Appeal decision. It's certainly not a Supreme Court decision, which means that it has sort of limited import.
Yes. That's quite true. But it started with the British Columbia Court of Appeal, and that's why the lower courts have been judging the same way since then. Okay. So when you read those cases, you will see the cases that they reference. My second...